Welcome everyone coming in. We're just going to give everyone a few seconds to join us. Thank you for joining us today. If you're already here, please feel free to drop your name and organization in the chat. We can get to know everybody a little bit and we'll get started in just a few. Alrighty, welcome everyone. Thank you for joining us today for the growing importance of workplace drug screening policies, procedures, and job descriptions. We're going to officially get started. Today, we're hosted by Drug Free America Foundation. They are a drug prevention and policy organization committed to developing strategies and educational programs that prevent drug use and promote sustained recovery. And a constituent of that program, a division of that program that I work for, is the National Drug-Free Workplace Alliance. Our mission is to be a national leader in the drug-free workplace industry by directly assisting employers and stakeholders, as well as everyone who is invited here today. Thank you so much for coming. And we provide drug-free workplace program resources, assistance, and support a coalition of the like folks. If you have not done so already, thank you to those of you who already have. Please feel free to introduce yourself and your organization in the chat box so we can see who we've got joining us today. And we do ask that if you can, please put your questions in the Q&A box. That will make sure that we see them, they don't get lost in the chat in any way, and we'll address them as they come up and as time allows. I do have to say that the content provided here is for educational purposes only, based on industry expertise. We have a couple of great experts with us today. It's not legal advice. Please make sure that you consult legal counsel before doing anything official. But you are in excellent hands today. We are joined by a few members of the Drug Screening Compliance Institute, DSCI. We have Bill Judge with us today. He is an award-winning attorney with over 38 years of experience in the workplace drug and alcohol testing industry. He is the co-founder and chief research attorney of DSCI. I knew I was going to mess that up. I practiced. Focusing on state, federal, and subject-specific compliance research, policy development, review, training, education, litigation support, and consulting. So really glad to have Bill join us today. We also have Nick Hartman, who is a managing partner and consultant with DSCI. And they're an accredited drug screening industry consultant, advisor, subject matter expert, professional researcher, trainer, and speaker, who has built, implemented, and managed drug-free workplace programs for thousands of employees across the US and abroad for over 18 years. You are in excellent hands today for sure. We have a couple great experts to speak with us about these workplace policies, job descriptions, and all of that. So we are very excited to get started. Again, just a reminder to put your questions in the chat and the Q&A box, preferably the Q&A box, but we'll keep an eye on both. And I'm going to hand things over to Nick and Bill. Thanks so much.
Thank you so much.
Appreciate it very much, Heather. Thanks for having us. Thanks to the Drug Free American Foundation and your org for hosting today's conversation. And thank you to everybody for taking the time out of your busy day to join us for today's call. Just to make sure, Heather, you can see my intro slide. Is that right?
Yes. Yep. Everything looks great.
Awesome. As Heather introduced, Drug Screening Compliance Institute. Essentially, Bill and I created to geek out, nerd out, research to death all the issues that employers have to deal with in regards to workplace drug and alcohol testing. From federal laws, state laws, now we see municipal level laws, the emergence of marijuana laws changing the landscape. We're going to talk about a lot of that stuff today, but essentially we handle anything and everything that has to do with workplace drug and alcohol testing compliance, from policy all the way to litigation support, everything in between. So if you have any issues, anything specific, feel free to reach out to us. As Heather mentioned, while Bill is a lawyer, we're not going to hold that against him today. We are not a law firm. I want to make sure that that's very clear. We are a consulting firm. So as you guys can imagine, everyone's employment situation is different. The information we're going to be talking about today is general information purposes only, but certainly welcome to field your questions as they come in. So make sure you manage that chat box. We'll handle those throughout the conversation, but we also carved some time out for some Q&A. All right. So we do have a little bit of a aggressive agenda. We're going to do a quick legal overview of where we stand today. We're going to jump right into policy for workplace drug testing policies and what, the philosophical and legal things that should be contained in there. We're going to get you an understanding of the difference between mandatory drug testing laws and voluntary drug testing opportunities. Then we're going to dive into related procedures as they complement the goals of that policy. And definitely a hot button item on our agenda is the role of job descriptions and how they're actually becoming more important than ever before and more critical than ever before. So we're going to delve into why that is. And of course, we'll leave you with some takeaways. And as I mentioned, we have just a little bit of time carved out at the end to answer any other questions. So
I might mention right at the top,
go for it, Bill.
Excuse me, before we get rolling too deeply into this, and so everyone knows, we're going to be focused primarily on states' rules. I noticed a number of you folks from your chat descriptions of who you are and what you do are federally regulated. That's great. We're not going to go diving deep into DOT or NRC rules, et cetera. We're going to be focusing on the states' rules. Primarily. So just so you're aware, because in our experience, and I've been doing this almost 40 years, everybody who thinks of themselves as federally regulated also has non-regulated workers. And you need to understand that to a certain extent, you got to take your federal blinders off and focus on what the state's rules are too.
Yeah, it's an important distinction, Bill, because like you said, there's always whether you have DOT regulated employees or not doesn't mean that your entire company is DOT regulated. And how you apply testing, how you conduct testing, the forms you use obviously play a gigantic role in the different processes. So while federal laws are pretty clear and cut, the regulations are there. Obviously, we help employers navigate those as well. But to your point, a majority of our conversation today is dealing with the non-regulated environment where state laws, case law apply. And again, thanks to the National Drug-Free Workplace Alliance for hosting today's conversation. So giving you just a quick lay of the land as it stands right now, obviously is subject to change at any time as this stuff is changing very rapidly. But there are currently 38 states, Washington, D.C., and a few U.S. territories that authorize the medical use of marijuana for a long list, a very wide variety, list of different medical ailments. Everything from serious things like cancer to general things like chronic pain. Also, currently, there are 24 states, Washington, D.C., and a couple of U.S. territories that authorize the use of marijuana for adults 21 years age or older. For recreational purposes. And the rules that are imposed on employers historically, which we'll get into a little bit more detail here, but typically didn't have any impact on the workplace, are now absolutely impacting what employers can or can't do with regards to testing and discipline. And we'll dive into those details. There are also currently 18 states that have authorized the medical use of cannabidiol or CBD, or also coined as low THC oils. Again, for a wide variety list of medical conditions. And the importance that we wanted to harp on here is that the language of these laws, whether there are employer protections or employee protections, vary greatly from one state to the other. And we're going to touch on some of those examples to kind of give you an idea of how they vary, but it's incredibly important for you to understand, especially if you're a multi-state employer, to clearly understand what the language of the laws are in each of the states that you conduct business in, because that's exactly what trips employers up. They try to apply a one-size-fits-all policy or rules and procedures across the company, but they absolutely the regulations and the rules will differ by state and even by municipality. So it's important to break that down and comply.
Yeah, absolutely. In fact, I talked with a customer yesterday, and they were trying to consolidate what they had. Now, they're a multi-state employer, and what they wanted to get to was basically a single set of procedures. And I said, folks, you just can't do that. The
Yeah.
rules are just too different state by state, and you have to take those into account.
We used to live in a world where you can have a nationwide zero tolerance drug testing policy, and those days are long gone with how many different laws and court decisions that we're dealing with today. So it definitely needs to be centralized. Now, just kind of giving you an idea on the issue. Why are we having this conversation today? Can't employers just stop screening for marijuana and solve all these problems? And obviously the answer to that is unequivocally no. But leaning on to our friends here at Quest Diagnostics, the nation's leading laboratory for workplace drug and alcohol testing, every year they analyze all of their laboratory data and share that with us. Gives us an incredible insight on the positivity rates in the U.S. workforce. And their latest data that they shared in 2023 showed a 20-year high of about 4.6% of all of those that were drug tested positive for some illicit substance. And Bill, we'll break it down real quick in numbers. So we do about 50 million or so a year.
Somewhere between 45 and 50 million. I've seen as high as 54 million estimated drug tests done every year just in the workplace. Okay, this doesn't account for the criminal side or family law or any of that stuff. It's just in the workplace. And just so you know where Quest fits, they're probably the largest or one of the largest. This is an analysis of 11 million tests that they analyzed last year.
So that's about 5% of those 11 million. You can do some quick back of the hand math. That's a lot of people testing positive for some form of illicit substance.
That's right.
And of course, marijuana is getting the elephant share of the limelight these days with the different laws passing and how that's evolving at such a rapid pace. But Quest specifically parsed out that marijuana positivities in the general workforce increased over 45% from 2019 to 2023. Not a huge surprise there as states continued to legalize for medical and personal use reasons, right?
Right.
What was kind of an alarming stat was that marijuana positives found in post-accident testing increased 114% from 2015 to 2023. Do you want to summarize why we think that is, Bill?
Well, it was interesting. You and I had been talking about this for a couple of years before this statistic came out, and interestingly enough, Quest also analyzed that number a little bit, and they said because of the large number of employers that are no longer doing pre-employment marijuana testing, the marijuana use didn't go away. It's going to show up in your program somewhere else, either as a result of reasonable suspicion tests or, as in this case, this statistic represents the post-accident testing. Now, we talked to a customer this morning, and they had stopped doing pre-employment marijuana testing just 2 years ago, and they contacted us because they want to start up again because they're seeing way too much current employee positivity.
Yeah, it's a head scratcher. So we know we were dealing with a labor issue before in years past, especially on the outside of the pandemic and such. And so employers were making these different changes. But now we're seeing the cause and effect, and it's statistically being analyzed from this data showing the increase in post-accident tests. As you said, you can't just bury your head in the sand and avoid it on the front end. It's absolutely going to rear its ugly head on the back end. So it's kind of a key for employers to understand that it's important to make sure you have a comprehensive pre and post drug testing process.
And by the way, it's important for people to understand as we talk about this pre-employment marijuana testing issue, a lot of people are under the misimpression that you can't do pre-employment marijuana testing in a lot of the states. It's just not true. There's a lot of restrictions in the states on what you can and can do with a positive result. Mainly what the state statutes say is that you can't discriminate against someone who, for instance, is a medical marijuana patient, if they happen to have a positive test result. But there are only a handful of jurisdictions that say you can't test. Big difference.
And we're going to dive into those details because it absolutely makes a huge difference, and the impacts to employments is very, very specific.
Right.
Rounding out some of these stats here, no surprise that in states that authorize the illegal adult use of marijuana, an increase of over 118% was found. States that authorize the medical use of marijuana, an increase of nearly 70%. That's stats between 2012 and 2020. Again, no surprise, as you authorize its use, people are going to use it. They're going to test positive in the workplace for it. Bill loves this stat. In states that have no legalized marijuana use at all, the positivity rate of marijuana positives still increased almost 60% in 2012 to 2020. And in the latest data was up another 6.5%. So again, regardless of if it's legal or not, it's still being used and still being found positive in the workplaces.
Not a huge surprise.
Yeah, not a huge surprise. We saw all the different stats outside of, during the pandemic of alcohol and marijuana sales skyrocketing. So we know that the substance is getting used, and we're not just sitting here talking to pick on marijuana. We did see increases in positivity rates for amphetamines and cocaine positives, 2022 to 2023, according to Quest data. The biggest surprise that we got from the latest data that really kind of took the industry, well, I shouldn't say by surprise, because a lot of those insiders in the industry know this happens, but it was the first time I think we saw a statistic around it, but workplace drug test cheating, specifically with urine drug tests, surged by more than 633%. That's an incredible number of people that are trying to beat the drug test.
Well, it's not a surprise in the fact that if you've got such a dramatic increase in marijuana use, people are going to start wondering, well, what can I do to protect my job? And they start looking into ways in which they can cheat.
And you can go online, you can go to your local grocery store or smoke shop, and they have all these products that are available out there free to use to try to beat the test. And it's clear with this data that that's absolutely being utilized, specifically with urine drug testing. Now, I'm going to wrap this slide real quick so we can get into the meat of our conversation. But as we mentioned, we're talking mostly about non-regulated drug testing today. DOT has their own testing regulations. Obviously, marijuana is still a prohibited substance, Schedule I drug, so still tested for in DOT drug testing programs. Outside of that, there are more than 1,200 state-specific laws and well over 20,000 court decisions that Bill and I track every single day that impact workplace drug and alcohol testing. And we're also going to talk about how these marijuana laws that are changing the landscape and really going to force employers to evolve on how they conduct testing and how they structure their disciplines for protections that are coming through these laws that protect the lawful off-duty use of these products. And we're going to get kind of lawyerly there, but we're going to talk about how these impact essentially the who, what, when, where, why, and how employers can test and what disciplines can be imposed.
Yeah, I will tell you that we just recently did a survey of all 50 states, and we noted that there are 10 states with specific language limiting employer action for off-duty use by their employees of marijuana. But there's also 28 additional states that by specific language or implication say that employers can only act against marijuana users if they find them to be using on duty or under the influence on duty. Now, I don't know how you want to analyze that, but even absent specific language prohibiting off-duty discrimination, that's pretty limiting in my view.
Yeah, I mean, we all know today there's no methodology, there's no per se limit that's been established to determine if someone's under the influence of cannabis or marijuana right now. So it's now leaning on what methodologies are available to show recent use or to correlate recent use while at work. And we're going to talk about another very term that we're going to toss around here called non-impairing cannabis metabolites.
That's right.
and how the science of cannabis is evolving very, very quickly, and already starting to be written into laws, like where I'm at here in Washington, where down in California and other states, Connecticut, et cetera, that are starting to get hip to the differentiation between impairing and non-impairing cannabis metabolites.
And I was explaining this morning to this customer, in the old days, the purpose for testing was to determine if anybody had used in recent days an illegal drug. Well, now that marijuana is legal, we can no longer approach things that way. It's a different world. Things are evolving. We've got to take that into account in analyzing our program and maybe updating our programs.
Yep. So those are all teasers for more information to come. But Bill, let's segue into a policy. We talk about it all the time. Customers come to us, and the first thing we ask is, "Where's your policy? What does it say? Can we look at it? When's the last time you took it out of the top of your desk drawer and dusted it off?
Do you know where it is? Yeah.
Do you know where it is? Do you know what it says?" Right. So let's start from a functional aspect of best practices, or where to get started on addressing a drug testing policy.
Without question, one of the first things we ask is, what states do you operate in? What are we talking about? Because we look at the specifics of the state. Then that tells us then where we go and where we find out what it is that applies here. And the first thing we look at then is the nature of the state. And when we talk about the nature of the state, we're talking about, and we'll show you in a minute, is it a mandatory state, a voluntary state, a required state? Are you required to do testing under certain circumstances? So we want to know the nature of the state itself. And where do we determine the nature? It comes from the statutes and the court cases in that state. Then we want to know what your goals are. Is safety the issue? Okay, fine. Client or contract driven. Please understand that even if a contractor or a client requires you to do a certain type of test as the employer, you're ultimately responsible for complying with state's rules. So as an example, if you're in Minnesota and your client says he wants or she wants all employees tested on a random basis, you got to remind them that in Minnesota, only safety sensitive workers can be subject to random testing. So you have to be aware of your limitations when it comes to client and customer relations. You may want to leverage the financial opportunities that we're going to talk about in a few minutes. Some of you may not be aware that there are 21 states that allow for a rebuttable presumption of intoxication when it comes to a work comp claim. Hey, that's where the money is, people. So you want to know where those opportunities are. Okay, so you also have to take into account things like the ADA. Now, marijuana users aren't protected under the ADA. Why? Because the ADA is a federal program. Marijuana is still a Schedule I drug. But you better be aware of state disability discrimination laws, because they may protect medical marijuana patients. OSHA rules. OSHA has dramatically pulled back on its position that you can't do automatic post-accident testing. Not the case anymore. But OSHA did leave a rule hanging out there that basically provides that if you're going to do testing of an injured worker, you've got to test everybody whose actions or lack of action may not or may have contributed to that injury. You've got union and collective bargaining rules that have to be taken into account, so you better be aware of what the latest discussions are there. And then policy limit or discipline limitations. Minnesota, we don't need to pick on Minnesota, but Minnesota's got a lot of details. In Minnesota, you can't fire somebody the first time they test positive. You've got to give them an opportunity at counseling. Yeah. So there's a lot to know.
And we see that the trend of drug testing is no longer a gotcha program. We're not trying to catch people and publicly humiliate them and get them out of the workforce. It's become more of a health issue to try to utilize drug testing for treatment purposes, to get people healthy so they can be a productive, safe, and functional worker. So we do hear a lot about second chance agreements, reassignments, like Bill mentioned, offering the opportunity to go through treatment and then return to have a pathway to return to the work. So these are all the kind of things that you want to consider in a drug testing policy. Also, we call this our circle of compliance here. There's so many different things to consider when it comes to policy, and we only have an hour to talk today, so we can't touch them all. But Bill talked about we talked about state compliance, marijuana issues. There's work comp opportunities, ADA, Bill touched on that already, OSHA. There's key agency decisions to consider, unemployment rules to consider, of course, federal or DOT rules. We talked about unions, but also key court cases, making sure you understand what the courts have ruled in each of the states on these issues, because that now becomes a legal precedent. So there's a lot to kind of understand there, and it absolutely needs to be conducted by state in each of the states that you conduct business in.
Yeah. So every state, every time somebody sits down to either revise or start a new policy, you have to ask yourself a series of questions. Why are we doing this? What's our goal? What's our purpose? Then you want to know who you're going to test. What are you going to test for? And does that differ by position? Where will testing take place? Are you going to do it on site yourselves? Are you going to do it at a local health clinic, or where at a hospital? Where are you going to do it? When will you test? That means, what we mean by that is the pre-employment suspicion, post-accident, et cetera. When do you want to do testing? How are you going to test? This is becoming increasingly an issue when it comes to marijuana testing. Are you going to continue using urine? Are you going to use oral fluid testing? Should you think about hair testing? All of these things have to be thought through. And then, of course, what are the consequences? And then you look at any state rules that apply to any one of those categories.
Yeah, we talked about testing methodologies. Oral fluid, which we'll harp on in a little bit, is absolutely gaining in popularity because of that it can detect more recent use of these substances, helping you meet that legal burden of use while at work. Also is the only methodology available today that I'm aware of that can test for Delta 9 THC specifically, or excluding other non-impairing cannabis metabolites, which we'll get into as well. So, and whether you choose to use urine and oral fluid between pre-screening and post-screening is absolutely something to consider as well.
Absolutely. And you have to know those rules if you're in states like Washington, California, Arizona, New Mexico, Connecticut, because they require you to, or limit you, I should say, in the action you take only if you find those substances for a marijuana user.
It's a different world, Bill. It's a different world that's changing fast. But
Exactly
so, you know, we talked about how nationwide zero tolerance drug testing policies are out the door. If you have one, you're in trouble because you're violating a law somewhere. I can guarantee it. Unless you only operate in Idaho, maybe then you might be okay. But let's talk about what's our strategy for addressing a policy, Bill.
Yeah, basically, we start with a company and their favorite wish list. You know, tell us what you'd like in terms of the who, what, where, when, and how, and we refer to that as your core company policy. That's the policy for the company, and there are no rules other than the ones that you set. Okay, now we'll add to that all state-specific addenda for the states in which you operate. So you've got a core company policy and then state-specific addenda that carve out the specific rules in every single state. And it's a much more efficient way to do it, because the guy in Minnesota doesn't care what the person in California has to deal with, and vice versa.
Yeah, and then pairing that with acknowledgement consent forms. And then we love to recommend policy implementation checklists when you're implementing a program or reviewing it for the first time. You know, there's policy legal items to include a policy, but obviously there's different action steps that you need to take and understand from a procedural perspective or administrative perspective that then need to conform with that policy. So
huge difference between your policy and the procedures for implementing that policy. And to that end, we are huge believers in checklists.
I totally agree. So, you know, Bill mentioned the nature of the state earlier. It's a kind of a legal term, but it definitely holds an incredible amount of weight. And we're going to cover each of these in our conversation as we go forward here. But mandatory states are essentially states where if you conduct workplace drug and alcohol testing, you must follow those rules. And whether it's a state law or case law, would consider drive those mandatory drug testing rules. Voluntary rules are essentially voluntary for employers to comply with, but come with some financial incentives. Bill mentioned utilizing drug tests to reduce your workers' comp insurance premiums, or to defeat a work comp claim, or to deny unemployment claims, so long as you voluntarily comply with that state's programs, which could be as simple as following DOT drug testing laws to a whole laundry list of different rules that you have to follow in order to be awarded that financial benefit. There are states where we consider required, meaning there's industry specific rules for like school bus drivers, bungee jump operators, all those different types of industries that have specific rules outside of state law. Of course, marijuana is driving a lot of the conversation. Impacts just about every state out there these days, whether it's marijuana or CBD, which we'll get into. Immunity laws. There's actually rules out there where so long as employers follow the rules, they're immune from lawsuits.
Yeah, Arizona, Alaska, Iowa, all have rules that basically provide if an employer followed the mandatory testing rules, then they have immunity from lawsuits.
Yeah, a huge financial advantage for employers. And then the ever decreasing open states where there are no specific rules, essentially employers are bound to follow industry best practices as they go and conduct drug testing. So we're going to jump into each of those throughout our conversation. But Bill, I thought, the lawyer being on the call, can you give us just a quick lay of the land of what the law consists of?
Well, it's very interesting because we talk to people and we ask them, well, how did you put this policy together? And they'll say, well, we followed the state law. Well, what is the state law? Well, the law consists of several things. It's the state statute, if one exists. It's any regulations that interpret that statute. And then, of course, more importantly, is the court decisions that also interpret and apply that law to a set of facts. So it's all three of those. It's the statute, the regulations, and the court decisions. That together makes up the law. And so you need to know what the law is in every single state in which you operate.
Yeah. And these detailed rules, essentially the language of the law, are incredibly impactful to how you go about conducting drug testing, how you conform your policy language, how you implement procedural items that conform with the policy. So we'll try to break it down and how it applies from a legal standpoint, but also most importantly from a practical standpoint.
And we'll show you in a few minutes how these can differ slightly, and that difference is very important.
But essentially understanding those rules are the blueprint for your success as it relates to policies.
Blueprint for protection. Know the rules.
Yeah. So mandatory and voluntary opportunities, again, mandatory rules are regulations, statutes, court decisions, or industry specific rules that employers must follow if they're conducting workplace drug and alcohol testing. And currently today, Bill, we have 31 states and several cities that have mandatory drug and alcohol testing requirements.
That's exactly right. And you can see essentially the yellow states are those that are mandatory because of existing statutes related to just drug testing. Obviously, the green states are marijuana laws that in some way make that state considered a mandatory state, rules you have to follow. Then the orange or rust-colored are both. They have both mandatory state statutes related to drug testing as well as marijuana laws. And then you have Virginia there. Virginia, a year ago or so, passed a law that basically says employers can't discriminate against employees' off-duty use of CBD. Now, our first impression was, why in God's name do you need that? But
we don't test for CBD anymore.
It doesn't get you high to test for it anyway. So that law exists. We don't know that it's ever been interpreted, but it's there nonetheless.
Yeah. Yeah. So, and again, the rules vary greatly and dramatically. So touching on a few of these state law oddities, some state laws you may not have known is, some states' laws simply require you to mirror your drug testing program with the Department of Transportation regulations. There are 7 states that limit the type of discipline an employer can impose. So like Bill mentioned, he was picking on Minnesota. Minnesota has a law on the books that you can't fire someone the first time they test positive. You must offer them an avenue to get treatment and to return back to work.
Yeah, Iowa, the law says that you can fire somebody who's positive for a drug, but not for alcohol, so long as the person's worked for you 12 out of the last 18 months. And it's Tuesday. No, I'm just kidding. 11 states and 2 cities limit or prohibit random testing. So here again is an example of why you can't have a nationwide policy. Because in these states, even though your company may call for random testing of everybody, you can't do it in those states.
Mm-hmm.
Okay. 5 states and 1 city prohibit observed collections. Are you aware of that? You can't just turn this stuff over to your providers, folks. You've got to know that if you're in these states or in that particular city of Boulder, Colorado, beautiful city I've had a chance to be in, you can't do observed collections.
Yeah,
Okay.
and that's common. That's used commonplace, especially when we talk about urine drug test cheating. What's the solution there in those states that prohibit observed collections, which are commonly used to make sure someone doesn't cheat the test, right?
That's right.
Add to that, there's 17 states and 2 cities that require employers to provide a split or retest opportunity. So if someone tests positive and they want to challenge that drug test result and send it off to a different laboratory to have it tested, there's these states and cities actually require an employer to provide that opportunity. Whether who pays and what the timing, that can vary dramatically, but just know that those laws are on the books, right?
Exactly. And there's 13 states and 1 city that limit or prohibit the use of hair testing. Okay, so as you're considering what test methodology to use, before you choose hair testing, make sure you check the state statute. 8 states specifically permit the use of hair testing. Okay, so some prohibit it, some specifically permit it.
Mhm.
5 states and 2 cities do not allow post-accident drug testing. What? You can't do post-accident drug testing in Connecticut. Why? Because the statute only authorizes employers to do testing when there's reasonable suspicion.
That's a head scratcher, Bill. That's a head scratcher.
Well, reasonable suspicion wins out. 16 states specify the limit of time that you can request a split specimen. Florida's my favorite because under the Florida Drug-Free Workplace Program, in which you would get a discount on work comp premiums, the employee has up to 180 days to ask for that split specimen to be done. Now, just think of the logistics of that issue. Okay, so those of you that are in the Florida Drug-Free Workplace Program, please understand what the limitations are under that program.
Mhm.
The rule in 6 states requires specific test cutoff levels that are different than national cutoff levels. Okay, employers are requested to pay for the cost of retesting in Rhode Island and San Francisco.
Yeah, so I mentioned how, the timing and who pays, that differs greatly, right? There are 3 states that require drug testing collectors to be registered with the state and to pay a fee in order to conduct workplace drug testing. That's a little known fact that's out there that catches employers, unfortunately.
Well, and I'll tell you, as a former litigator, the first thing I would start asking in those states is show me the fee that's been paid and show me the registration
Right.
that you filed with the states.
Yeah. There's 3 states that limit or prohibit employers from conducting breath alcohol tests. Say what, Bill?
No,
Oh,
you can't do a breath test in Maryland. Better
yeah.
not.
So you have to do it only via blood. So again, the letter of the law makes a gigantic difference there. We already picked on Minnesota. I'll skip
Yeah,
over.
leave Minnesota.
There we talk about policies as being a best industry practice, but there's actually a few states that mandate that you have a policy. In fact, the state of Maine, your policy must be submitted to the estate and they must approve it before you can
Exactly.
implement and begin drug testing. So it's
That's
important to know those legal, actionable, administrative steps. And then we talked about this before, the trend of states limiting when you can test for marijuana, how you can test for marijuana, the prohibition of testing for non-impairing cannabis metabolites, and then of course what disciplines can be imposed if someone testing positive for marijuana are changing at an incredibly rapid pace. Just to give you an idea, where I sit here in Washington State, pre-employment drug testing for cannabis is prohibited unless you're screening for specifically Delta 9. In California, that rule applies to all reasons for test, not just pre-hire. So they're now mandating that you use a methodology in a laboratory and a product or service that can specifically screen for Delta 9 and no other non-impairing cannabis metabolites before you take any adverse employment action.
And please understand, our research shows and our discussions with scientists tell us that oral or urine testing will not reveal the existence of Delta 9.
Yeah, urine drug testing essentially was created, just like the concept of drug testing was created to find the presence of illicit substances, past use or historical use, where with the topic of marijuana now, we're getting far more finite And utilizing a method like oral fluid is essentially required so you can show more recent use and specifically for Delta 9.
There was just a paper put out, it's not yet published, it's by the Oxford Press, and it's well-known scientists, very well-known scientists in our business. And they basically said, come to the conclusion, if you're going to use urine testing, you would have to have a 5 nanogram cutoff level to even identify the primary metabolite of cannabis, which is hydroxy THC. And in order to, in an attempt to use urine for Delta 9, it can't be done.
Yeah. Important distinction. The science is definitely a little bit behind. I think we're a decade behind or so, but you see workplace drug testing evolving just as the letter of the law is forcing it to do so. Jumping into a couple of state examples here, again, we're going to pick on the state of Minnesota blatantly this time, but Minnesota requires that has a mandatory drug testing law that is an incredibly arduous law impacting all kinds of different components of workplace drug testing, but specifically with a policy requirement and written notice requirement. So there's specific things here that not only do you have to have a policy, but it must contain these 6 items.
Right, and you've got to identify the employees and job applicants subject to testing, the circumstances, in other words, when are you going to test, the right of an employee or job applicant to refuse, that's got to be in your policy, so just type it right in there. Any discipline or other adverse action that's going to be taken, you've got to specify it. The right of an employee or job applicant to explain the positive result. That's not just with the MRO, by the way, that's in addition to. And any other appeal or procedures that you have that an employer or applicant can take advantage of.
Yeah, the state also requires notice. So when you're implementing a drug testing program, that requires written notice to be sent to all employees prior to adopting the policy. There's other states that require written notice for the notice of a drug test positive.
Yep.
And if you're handling drug testing positives for a minor, some states mandate that you send that notification via certified mail to their parent or guardian.
Tennessee and Iowa, parents,
Yeah.
wonderful dinner time conversations. Yeah.
So it really gets into the finite details here, and you switch over to our friends at the state of Oklahoma bill on Section 555. The fact that these guys have an incredibly arduous drug testing state law, right?
This state's law is so detailed that I typically say to them, if you're in Oklahoma, move.
Yeah.
Oklahoma is a great state. Love it very much. But if you're in Oklahoma and you're going to do drug testing, please be aware, very, very detailed rules that you have to take into account.
And again, it's another state that requires you to first adopt a written drug testing policy, must include these 11 different items in here of what needs to be contained in there. And then, of course, there's a notice requirement, at least 10 days notice to all employees prior to implementing the program. So these are, again, we talk about policy things. These are all the things that you need to consider in your policy, but procedural items like notice, implementing a drug testing policy, which is entirely different, right?
Yeah, exactly. Like, fortunately, in Oklahoma, they did make it easier on employers, and they allowed them to essentially provide the information in a number of different ways, including hand-delivered mail and intranet and all that kind of stuff.
Yeah. So voluntary laws, shifting the conversation a little bit. Again, our laws, regulations, statutes are programs. So we typically see drug-free workplace programs that if employers voluntarily comply with the letter of the rules in those programs, they can leverage financial opportunities. And Bill is famous for getting on stage and yelling at the masses saying, this is where the ROI is in drug testing. This is where the money is in drug testing. You know, oftentimes we have customers that participating in these programs and the financial advantages that they leverage cover the entire cost of their drug testing program when done successfully. So again, these are programs that offer discounts on your workers' compensation premiums, insurance premiums, or to utilize a positive drug test to defeat a work comp claim, or to defeat an unemployment claim, to deny unemployment benefits, or we talked about immunity from lawsuits.
Right. And then these are the 12 states that offer work comp premium discount programs, typically referred to as drug-free workplace programs. And again, you've got to be very careful and check the details and the requirements of each of these because they can be very, very detailed. These 21 states, my favorites, by the way, If you copy anything, and you're welcome to copies of all the slides here, by the way, somebody asked that question. Yes, you can have access to the slides, but if you're going to copy one, copy this one, please, because in these 21 states, there is what's known as the rebuttable presumption of intoxication defense to a work comp claim. What does all that mean? Well, it means that if you have set up your procedures properly in accordance with states' expectations, and somebody tests positive, they're presumed intoxicated and they're presumed to have caused their own injury. Okay, now the burden shifts to them to establish that something else caused their injury, not being drunk.
That's an incredibly tough burden to prove, right, Bill?
In Illinois, it's the law requires them to show that something else was the sole cause.
And that's a near impossible task.
Yeah.
And you see here a stat from the National Safety Council, our friends there show that, $40,000 is the average workers' compensation claim. Your drug test costs what, about, 30 to 40, 50 bucks, something like that. You're going to get a pretty big ROI if you're leveraging some of those programs and utilizing the advantage of that.
Nick and I have a customer, and they came to us and they'd heard about me yammering on about this issue, and they wanted to set up a pilot project. So we set them up in 6 states. And in less than 12 months, they reduced claims in just those 6 states. They reduced claims 20% and saved $6.5 million.
Talk about added to your bottom line there.
Yeah, this stuff works.
We talked about required state laws. There's some industries that are required. We typically see these when public work contracts, those in home health care or elderly care, child care workers, taxi or shuttle bus service drivers, school bus drivers, of course, and then Bill's favorite, the bungee jump operators, making sure that there may be some state laws that specifically mandate drug testing requirements for these different industries.
That's our good friends in North Carolina.
Does that make you more confident to go on a bungee?
I wouldn't go anywhere near them.
Oh, okay, all right. We talked about immunity laws. Again, some states have laws that relieve employers of any immunity or liability in lawsuits, so long as they follow the specific immunity rules. And then the decreasing amount of states now that are open, meaning there's no drug testing state law, regulation, statute, or case law that impacts workplace drug testing. So then employers are now required to follow or suggested to follow industry best practices for testing. All right, so Bill, just with the convenience of time, we're going to make sure we plug to the next talking about procedures here and the difference between a policy and procedure. And as you say, a piece of paper could be the greatest policy ever, but if it doesn't come with proper procedures, then it's pretty much useless, right? How do you actually apply this practically within the workplace?
Well, exactly. I mean, you can put a policy together that's well written, follows the state statute and regulations, but if you don't look into the details of the procedures, like Minnesota's perfect example, some of the procedures include the notice provisions we talked about, but also that you have to post notice of the policy. If you didn't properly post the notice, then
or even the testing, the discipline thing. You're not going to potentially say in your policy that you can't fire someone the first time they test positive, but that's absolutely needs to be an important procedural item so you don't go and violate that rule, right?
At least those people who run the programs better know these differences.
That's right. So again, a policy describes that here's what our goals and the rules are, and procedures are how we're going to go about conducting and complying with those rules. So, procedures detail things like how you distribute the policy, what any state or local limitations you need to know of are, whether a policy or an acknowledgement needs to be written, whether you need to provide notice, where testing is going to occur. Again, these are things that you may not want to include in a policy document, but definitely need to be included in a procedural document so those that are enforcing the policy know how to properly comply with your own rules and obviously any state or federal rules as well. But all these different items are something you should consider from a procedural aspect. And Bill, I think the next slide is great because it breaks it down a little bit on how this differs, right?
Well, these are just examples of what we've been talking about here in terms of how the statute may specifically say one thing, but the regulations or court decisions might say something completely different or slightly different. So here's an example in Oklahoma where the statute itself on the right-hand side there, on the left-hand side, you see it defines what a drug is, right? Okay, well, you go to the regulations in Oklahoma and it says, okay, the statute says this, but you're only allowed to test for Schedule 1, 2, or 3 drugs. All right. Do you know what those are? I mean, how do you know? How do you find out? Bottom line is, there was a well-known, well-publicized case, the Creekmore decision, where the employer lost because they didn't limit testing to a Schedule 1, 2, or 3 drug. They fired somebody for testing positive for a Schedule 4 drug. Okay, so be careful. North Carolina. North Carolina is an example because the state statute doesn't mention notice at all. And yet, in the regulations, you'll find there are 2 different notice provisions, depending both before testing and after testing, okay? And then finally, in Iowa, the state statute describes what an accident is that allows you to conduct a post-accident test, okay? Chapter 88 reportable, more than $1,000 in estimated damage, et cetera, et cetera. Okay, the Iowa Appellate Court found in a case that under one particular circumstance, soft tissue injuries, that's not considered an accident. So in that particular case, this woman had a carpal tunnel syndrome and had been going to treatments for over a year. And their new HR person comes in and says, well, wait a second, when she's doing that, we have to get a drug test when she does that. That's an accident. That's an injury. Supreme Court said, no. And by the way, the employer owed the lady $40,000. The court specifically defined what an accident is, and it specifically ruled out soft tissue injuries. Okay, so that's just a little evolution and nuance that you'll find in some of these states that you got to be real careful of.
Yeah, and like I mentioned before, we're big proponents of procedural checklists. Commonplace in employment world are called scope of works that get put together standard operating procedures that get put together on how to implement and how to comply with each of these different components of the of conducting workplace drug and alcohol testing.
Right.
And yeah, $40,000 mistake because they didn't understand what the letter of the law was, right? And we also, just briefly before we move on to job descriptions, we talked about medical marijuana and state disability discrimination laws. You know, I don't know if anybody knows on this call, but in New York, anybody that's authorized under state law to use medical cannabis is considered disabled under state law, thus afforded the rights of state human rights laws. So essentially protecting the underlying medical condition for which they were authorized to use cannabis.
Yep.
There are states that prohibit discrimination in that both on the status, the fact that they are a medical marijuana authorized user, and also on the underlying medical condition in which they are authorized to use the substance. So it gets really detailed with these state laws. It's important to understand and dissect it by state, by city, etc. All right. So finally, with job descriptions, the critical role of job descriptions, where before it seemed like a very mundane administrative task to create a job description, you're trying to hire somebody, but now they're holding a whole lot more weight than ever before. And Bill, remember that guy that called us, said, you know, everybody in our office is safety sensitive, right?
It's not going to necessarily work. You cannot just simply say everybody here is safety sensitive. That you may think so, but the state courts may not. Recently, Supreme Court decisions in both Minnesota and Iowa, the court said it's not your environment that determines whether or not you're safety sensitive. It's the nature of the job.
Yeah, and this plays a huge role in safety sensitive carve outs that we're seeing that correlate with marijuana laws. Like the state of California, they had a safety sensitive carve out in their cannabis pre-employment or their cannabis testing prohibition that that included the construction and building trades.
Right. That's
are
it.
exempt from the rules.
That's
What
it.
the heck does that mean? They didn't, of course, they didn't define it for us, but anybody that has a role, a job description that's in those roles is thus exempt from the state law. In the state of Washington, where I stand here, law enforcement was included. Anybody in the airline industry were included. There was a general safety sensitive carve out for any job that could an impairment, workplace impairment could cause death. So you got to look at what those safety sensitive carve outs are, the definition of those safety sensitive carve outs, and then most importantly, discern in detail your safety sensitive from your non-safety sensitive workers. And it's important to get down to the granular level. What is the specific job function that they're doing that makes it safety sensitive? As Bill mentioned, you can't just say we're in a warehouse environment. You can't just say they work in a kitchen. You got to say that they work around boiling liquids or sharp objects, or they operate heavy machinery. You have to get really granular and detailed, because essentially, when you go to leverage your defense, you're going to have to justify and prove in the court of law potentially as to why you deem that job as being safety sensitive.
Right. New York City has a rule that you can't do pre-employment marijuana testing unless it's a safety sensitive job. And they list samples of what those are. Well, you've got to get specific so that if you think you've got a safety sensitive job in New York City, that you're able to do marijuana testing.
That's right. And this is just comes down to a federal level, the term essential functions, and it includes a written, job description. So again, what we're harping here is make sure, if you haven't done so already, revisit your job descriptions, completely analyze them, especially making the distinction between safety sensitive and non-safety sensitive, and make sure that you're confident to protect that stance if or when you're ever challenged in the court of law. All right. I know we're bumping up on time here. We had a
Yeah.
lot to talk about, but I wanted to leave some guidance and action items, kind of recapping what we talked about today. So make sure, again, you clearly understand the language of the laws, federal level, state level, municipal level, that apply to each of the states that you conduct business in. Make sure you've created, implemented, and routinely review a drug-free workplace policy that has your stance on all the different aspects of testing, maybe even including a specific statement on your stance on cannabis use. And make sure you stay up to date on regulatory changes, as this stuff is changing pretty darn fast. Make sure you have sound processes and procedures that complement the language of the company policy, giving clear guidance for your managers and supervisors on enforcing your policy, especially in reasonable suspicion post-accident situations, or those where decisions need to be made in the heat of the moment. Make sure you're analyzing the different drug testing methodologies and products that are out there. We hear a lot about oral fluid drug testing. It's definitely going to be gaining popularity and continuing to increase as urine dominates the market right now. But it leverages such great benefits of detecting recent use, the ability to identify specifically Delta 9, and there's others. The fact that you almost eliminate cheating with an oral fluid drug test because they're always directly observed. I mean, that's a whole different conversation of itself. Make sure you're addressing that.
I'm sorry, DOT estimates that it could take up over 45% of the marketplace eventually.
Yeah, it's just got so many different benefits, and it's been used in a non-regulated workplace environment for years. So make sure your managers, supervisors understand the details of the drug testing policy and the procedures. Train them, invest in your managers and supervisors so that they confidently know how to recognize the signs and symptoms of workplace substance use, and more importantly, what action steps to take, again, in the heat of the moment there. Make sure you document and review your comprehensive job descriptions, especially those roles that are safety sensitive. Be prepared to defend your stance in the court of law if you're ever challenged. And for the medical marijuana side, as we talk about state human rights laws and disability discrimination laws, make sure you're prepared to engage in an interactive conversation with that medical marijuana patient to determine if their underlying medical condition can be reasonably accommodated or not prior to taking any adverse employment action.
Yeah, I will mention one case real quick, and I know we're up against time here and want to get to the questions, but the Massachusetts State's Supreme Judicial Court said that employers should treat medical marijuana patients like any other prescribed medication. And even though they found that the employee didn't have a right to sue their employer under the medical marijuana law, they said, oh, but under the state's disability discrimination law, your employer should have had an interactive conversation with you to determine if you could perform the job.
And that's kind of a new concept for marijuana. So it impacts just about every employer out there. So
this isn't 1988. I want to address one question real quick with Johnny Rogers there that was on the queue. And he asks about safety sensitive. And I can tell you that if you'd like to get in touch with us, we do have a chart on states that have defined safety sensitive. And there are a lot of them. Okay. So if you're looking for a definition of safety sensitive, first look to the state law and see if there is a definition, and we can certainly be happy to provide that to you.
He mentioned about opioid use and prescription drug use, opioids specifically being called out.
I'm far more concerned about opioids than I am about marijuana. Trust me.
And again, I think it's a policy thing where you need to state in there if anybody's using a controlled substance that could affect their ability to conduct their job safely, must report that to HR.
And you need to have a good relationship with your MRO, because your MRO should be, if they're not already, even if they reverse a positive lab result to a negative, they need to be telling you if there's a potential safety issue. Okay, and that will help address some of these opioid prescriptions that are floating around out there that could cause you trouble.
And there was a good question also from Johnny there about, if you think someone's cheating, and can you subject them to an observed collect, or if you can't subject them to an observed collection by state law prohibition, can you mandate an oral fluid test? And I think this is absolutely going to be a common practice to have utilize both urine and oral fluid synonymously in your program, depending on situational things just like this, where even with DOT, once they approve and get all that stuff, the infrastructure ready to do DOT drug testing, they allow employers to flex from a urine drug test to a oral fluid drug test if circumstances allow.
And Nick, can you read what's Tim's question there, our good friend Tim?
Yeah. So this is the big lawyer question, Bill. So we talked about states that limit random drug testing, right? And is based where the employer is, the employee is. What state laws apply is the golden question that we always get, right?
Tim has always has the best questions. This is this situation where if you asked a room of 10 lawyers what state's rules apply, 9 of them are going to jump out the window, and the 10th guy's just too stupid to jump. But our research shows, bottom line, that there are a lot of factors that will go into what amounts to a preliminary hearing to determine which state's laws apply. But the bottom line is that it's probably going to end up being the state where the work is to be done.
More often than not. So I'm going to rope Heather back in here because I know we took up the lion's share of the time. I know we're at the top of the hour. I want to be respectful for people's time. We can certainly continue to answer questions, but it's totally up to you.
Yeah, we're here all day.
I really appreciate everything that you all went over. I do know that if anyone has to go, we very much appreciate your time. The National Drug-Free Workplace Alliance is here to help you as well as Nick and Bill. So please feel free to reach out to us. We will send along a follow-up email with the slides and the recording. So be on the lookout for that so we can always follow up with you individually if you would like. And we really appreciate you taking the time out of your day. With all that being said, do we want to, if both of you have the time, we'll follow up on these last questions?
I think there was just one we left unaddressed that came in was about temporary staffing, Bill. So if you're using temporary staffing or labor for a company, do they have to meet your company policy?
Yes. And it may very well be that they're going to have to meet the staffing company's policy, as well as an addendum, essentially, for the client company policy too. There are a lot of court cases out there where holding staffing companies accountable for the mistakes that are made in drug testing programs. So just because you are not or may not be the employer, which is an evolving definition if you follow that universe, then you have to be really, really careful about what rules are going to apply to that individual. And you want to look at it from the individual's perspective. That drug test that's done, okay, who's that drug test done for? Under what circumstances? Okay, so just be careful.
Yeah. So I think we're good on questions unless there's any final. But again, happy to follow up with anybody either through the Drug Free Workplace Alliance or directly. Just let us know.
Fantastic. I took a brief look over. I think we've gotten everything that we could get today. I see a few thanks coming in through the chat. So thank you all for joining us. Bill, Nick, thank you so much for your time. I learned a lot. So it's very much appreciated. And like I said to everyone, we will be following up. You'll hear from me in the next couple of days, and we'll make sure that everyone's contact information is included. And thank you so much for joining us today.
We thank you.
Take care.
Goodbye.